Okay, let's discuss the special types of workers. This group of workers are treated differently under the labor code. There are different standards used when it comes to wages, employment contracts. So we have to study them. So when can we say that the company can accept apprentices? First, the company must be engaged in an apprenticeshable occupation. When you say apprenticeshable occupation, it means that it is approved by the TESDA. So this refers to highly technical industries, because under Article 60, only employers in highly technical industries may employ apprentices, and only in apprenticeshable occupations approved by TESDA. So it is now the TESDA, the government agency, that approves these apprenticeship programs. Without approval by TESDA, the employees or the apprentices hired will be deemed regular employee, because there is employer-employee relationship between the apprentices and the employer. This is the ruling in the case of Nito Enterprises versus NLRC, September 29, 1995. So what are the features of this special type of workers, the apprentices? First, they must be covered by an apprenticeship agreement. What is an apprenticeship agreement? It is a contract wherein the employer binds himself to train apprentices, and the apprentice also in turn accepts the terms of training. The apprenticeship agreement under the implementing rules of TESDA law, Section 1, Rule 10 of the implementing rules thereof, apprenticeship agreement is a contract where the prospective employer binds himself to train the apprentice, who in turn accepts the terms of training for a recognized apprenticeshable occupation, emphasizing the rights, duties, and responsibility of each party. Remember, the minimum employable age of an apprentice is 15 years old. Under Article 61 of the Labor Code, the period of apprenticeship shall not exceed 6 months. And the benefit or privilege given by law under Article 61 is that apprenticeship agreements providing for wage rates below the legal minimum wage should not be below 75% thereof, and may be entered only into in accordance with the apprenticeship program approved by TESDA. So this payment of wage rates, we have to remember that this also must be approved by TESDA. It will be incorporated in the apprenticeship agreement. Otherwise, you will be bound to pay the minimum wage if not approved. In addition to the age of 15, the minimum employable age, the apprentice must possess vocational aptitude and capacity for appropriate test, and finally should possess the ability to comprehend and follow oral and written instruction. In order to encourage employers to hire apprentices, Article 71 of the Labor Code provides tax incentive. So if you will be asked on the tax incentive given to employers who hire apprentices, there is an additional deduction from taxable income of 1/2 of the value of labor training expenses incurred for developing the productivity and efficiency of apprentices for those persons or enterprise organizing an apprenticeship program, provided that it is duly recognized by TESDA and approved by TESDA, and such deductions shall not exceed 10% of direct labor wage. Provided finally that the person or enterprise who wishes to avail himself or itself of this incentive should pay his apprentices the minimum wage. So you have to remember that this tax treatment can only be availed if the employer, more importantly, will pay the apprentices the applicable minimum wage. Because as what was mentioned earlier, there is an option of the employer to pay not below 75% of the applicable minimum wage to all apprentices. But if you want to avail of tax deduction or tax incentive under Article 71 of the Labor Code, in addition to the other requirements, these apprentices should receive the minimum wage. Should there be any complaint regarding apprenticeship programs, you have Article 65 of the Labor Code. It provides that upon complaint of any interested person or upon its own initiative, the agency of the Department of Labor or its authorized representative shall investigate any violation of Apprenticeship Agreement pursuant to such rules and regulations as may be prescribed by the Secretary of Labor and Employment. So if there is any question asked regarding apprenticeship, it will be a situation where the apprenticeship will become a regular employee, or when the apprenticeship will be entitled to minimum wage. So if you hire an apprentice, but your apprenticeship program is not approved by TESDA, then the employee becomes a regular employee. And also do not hire or go beyond the 6-month period, because the law only limits apprenticeship period to 6 months. If you go beyond 6 months, then the employee becomes regular. Another scenario would be, when would an apprentice receive the minimum wage? You have to qualify. If the employer desires or wishes to avail of the tax incentive provided under Article 71 of the Labor Code. So that's apprentices. Now let's go to another special type of workers. We are talking here of handicaps. Who is a handicap worker? Now our guide will be RA 7277, otherwise known as the Magna Carta for Disabled Persons as amended. According to this law, a handicap refers to a disadvantage for a given individual resulting from an impairment or disability that limits or prevents the function of activity that is considered normal given the age and sex of the individual. So we are talking here of handicap, not disabled persons, because qualified disabled persons are not considered special types of workers. Now, who are handicapped? or handicap employees or workers. They are those who cannot function normally given their age. They may have the physical age of 30, but they have the mental age of 10 or 11. These are what we call handicap workers. An employer who employs handicapped workers shall enter into an employment agreement with them, and which agreement shall include the names and addresses of handicapped workers to be employed, the rate to be paid, which shall not be less than 75% of the applicable minimum wage, the duration of the period of employment, and the work to be performed by handicapped workers. Now let's look at the incentives for employers if they hire handicapped employees. The employer or the entities that hire handicapped or disabled person, this time including disabled person, are entitled to additional deduction from their gross income equivalent to 25% of the total amount of paid salary and wages to disabled persons. Provided that such entity present proof as certified by the Department of Labor that the disabled persons are under their employ, and provided further that the disabled employee is accredited with the Department of Labor and Employment and the Department of Health as to his disability, skills, and qualification. In addition, private entities that improve or modify their physical facilities in order to provide reasonable accommodation for disabled persons shall be entitled to an additional deduction from their net taxable income equivalent to 50% of the direct cost of the improvements or modification. A handicapped worker can be hired also or qualify as apprentices. There is no prohibition to that. Under Article 81, provided that their handicap is not such as to effectively impede the performance of job operation in the particular occupation for which they are hired. If you will be asked to distinguish between a handicapped and disabled employee, the main distinction would be when you talk of a disabled employee, there is an absence or impairment of a physical or mental development or function of an individual resulting from disease, illness, accident, injury, or social trauma occurring prenatally or acquired postnatally, thereby imposing limitations or barriers to independent living, intersocial relationship, mobility, education, and employment. When it comes to a handicapped employee, the disadvantage suffered with the person here makes achievement unusually difficult because of some physical or psychosocial impairment. It also refers to cumulative effect of obstacles which disadvantage interposes between the individual and his maximum functional level. So an example of a disabled employee, you have an amputated person whose legs were both cut due to accident. But this person, the impairment to function normally is because of the cutting of the leg. A handicap may have complete limbs and everything, but there is the problem when it comes to, there's what we call a psychological or mental impairment which hinder the person from performing functions that are expected of his or her age. So, a person who is autistic is considered a handicap. An autistic person has complete limbs but cannot function based on his age or as expected of his age. But these persons can still be hired. They can do routinary functions, and they should not be discriminated. In fact, they should be welcomed by society. They should be considered members of society who can still be productive. So if the employer will hire this type of employees, then they deserve commendation because it is like fulfillment of their corporate social responsibility to help disadvantaged persons like handicaps. That's why the law is giving more incentives to to employers who hire handicaps than those who will hire apprentices. Let's go to learners. Who is a learner? Under Article 73 of the Labor Code, learners are defined as persons hired as trainees in semi-skilled and other industrial occupations which are non-apprenticeable and may be learned through practical training on the job in a relatively short period of time which shall not exceed 3 months. Under the implementing rules of TESDA law or otherwise denominated Republic Act 7796, learners refer to persons hired as trainees in semi-skilled and other industrial occupations which are non-apprenticeable, and learnership program must be approved by TESDA. The same is true with apprentices. Not applicable when it comes to hiring of handicaps. So when learners may be hired? Learners may be employed when no experienced workers are available. The employment of learners is necessary to prevent curtailment of employment opportunities, and employment does not create unfair competition in terms of labor cost or impair or lower working standards. So this is what we call the limitation when you hire workers. First, there must be no experienced workers available, and the employment does not create unfair competition in terms of labor cost or impair lower working labor standards. If this will happen, then the hiring of learners will be considered invalid under Article 74 of the Labor Code. When it comes to learnership agreement, it should include the following. First, the names and addresses of the learners. Second, the duration of learnership period, which shall not exceed 3 months. Then the wages or salary rates of learners, which shall begin not less than 75% of the applicable minimum wage. And finally, commitment to employ the learners if they so desire as regular employees upon completion of learnership. Under the same article, referring to Article 35, there is a situation where learner becomes regular. When learners have been allowed or suffered to work during the first 2 months, shall be deemed regular employees if training is terminated by the employer before the end of the stipulated period without fault of the learners. So that is the condition where learners become regular employees. So take note that the period of learnership shall not exceed 3 months. So if you will be asked, can a learner become a regular employee? First, under this last paragraph of the enumeration as to what the learner agreement should contain, contemplates the situation when learner becomes a regular employee. For the first 2 months, if the contract is terminated without fault of the learner is considered regular employee. Another scenario, if the learnership program is not approved by TESDA, then the employees hired therein shall be considered regular employees. Finally, if Article 74 is violated, then learners will be considered regular employees. Because in this case, the employer hires learners in order to defeat the competition of other companies in terms of lower labor cost.